Hello, everybody. My name is Peter Phillips, and I'm the director of the ADR Skills Program at New York Law School. I welcome you to our second Zoom CLE event of the year and our final event of this term. We're very fortunate to be able to have the information and enthusiasm of the Presumptive ADR team of New York courts to assist us this morning, and I will help. I hope that Danielle Shalov will introduce everyone, and she will also be the moderator for this evening's event. For those of you who took part in our earlier inaugural Zoom CLE, I appreciate very much your patience and the difficulties that you had to be overcome in order to get everyone their CLE certificates. At this point, everyone from last month's event should have received their certificate. If you haven't, you know where to reach me. It's adr@nyls.edu, and I'll make sure that happens quickly. I have tested and retested the links this time that you're supposed to click in order to make sure that you fill out the code words and make sure that you submit your CLE, and it ought to work. If it doesn't work, I again ask simply for your patience and your good humor, and we'll make sure that everyone's CLE is supplied to them. Also, during this session, you will hear reference to Part 146 in the New York Court Rules, and those have also been supplied to you as part of the materials for the course. There are certain training requirements in Part 146, and New York Law School has been approved as a provider of online training for Part 146. Danielle will be leading the first online training for that purpose during the week of July 20. And everyone who is on this broadcast will receive information if you're interested in learning more about that training or if you're interested in registering for it. With that, I introduce you to Danielle Shalov, who will moderate this event.
Thank you, Peter, and thanks to New York Law School and the Dispute Resolution Skills Program for hosting tonight's panel discussion. As Peter mentioned, I'm Danielle Shalov. I'm an adjunct at New York Law School, where I'm the director of the Mediation Clinic. And tonight I'm going to serve as moderator for a discussion about recent developments in presumptive ADR in New York courts. The first thing I want to bring up for all participants is that you'll see at the bottom of your Zoom panel that there's a Q&A button, and we'll ask that if you have questions during the presentation to please put them into that Q&A, into that field. And also, if you could include the panelist who you're directing your question to, if you could include that in your question, it'll just help expedite us when we get to the Q&A at the end of this session. Before we begin, though, I'm going to introduce the panelists in just a moment, but we'd first like to hear from you, the audience. We have a few questions, and we're going to run a poll. And this is just to get to help us understand who's here, and so that we can really tailor this presentation to those who are in attendance. So if we would be so kind as to put up the poll, and then we can take a look at the results. Or do I run the poll? Here we go. I'm going to launch the poll. And so if everyone could just take a moment and fill this out, you'll see there are about 10 questions. All right, and the answers are starting to come in, so we're just going to give a few moments, and this is really just so that we know who's in the audience, and I think that'll help shape the conversation. And can everyone see the results, or it's just me? Probably just me. All right. So as soon as this is done, we'll have a good understanding of who's here, so we're just going to give, we have about 60% of people have voted, so we're just going to give it a few more minutes, or a few more moments rather, so that we can get an idea. The numbers went down for a second. I don't know why. Someone took something back. Okay. All right. All right, so I'm just going to quickly, I'll end the poll in a moment, but this way we can still have people responding as we start to take a look at who's in attendance today. And from here, the first question was, are you a mediator? And 58% said no. So that's interesting in guiding our conversation. 42% said yes. Attorneys, there are many attorneys on this call tonight. We have about 90%. If you're a mediator on a state court roster was one of the questions, and predominantly the answer to that, almost 75%, is no, not on a court roster. Are you a mediator for a local community dispute resolution center? 90% said no there, only 10% said yes. The next question was, would you be interested in joining a state roster? And here, happily, 74% so far said yes, they're interested, which is great because we have information about that tonight. Do you represent clients in mediation was a question. And here it's really a split between about 50% on each side saying yes and 50% saying no. Have you done virtual mediations? The majority here, about 66%, said no, have not participated in virtual mediations. And for those who have done virtual mediations, which you rated as successful, 34% said yes, 62%, the majority, said unsure, but that goes in line with the fact that many have not had the opportunity yet to do that. One of the questions is, would you be willing to offer free mediation services to low-income litigants? 63% said yes. And have you ever attended a mediation either as a participant or a lawyer? We have, as a participant, about 30%, as a lawyer, 62%, and no to all of the above at about 27%. So I'm going to share these results. If people want to take a look, they'll be available. But it really seems as if we have a lot of people who are interested in mediation, perhaps who have not mediated, but certainly there seems to be a strong interest in joining the court rosters, which is great because that's something that we're going to discuss tonight. So thank you so much for participating in the poll. As I said, it's going to help shape our conversation. For now, I'd like to start by introducing our panelists for this evening, and we're very lucky to have them here tonight. I'm going to start with the poll. All right, I'm going to start by introducing Lisa Courtney. Lisa Courtney is the statewide ADR coordinator for the New York State Unified Court System. She oversees the ADR office, which includes the Community Dispute Resolution Centers Program, the Attorney-Client Fee Dispute Resolution Program, the Collaborative Family Law Center, and the Part 146 Training Program and Approval Process. Lisa assists court in developing ADR programs. She teaches mediation and settlement skills workshops for judges, court attorney, legal service attorneys, and private practitioners. She also coaches attorneys and law students in bar-sponsored mediation training programs. She's an advisor to Chief Judge Janet DiFiore and Chief Administrative Judge Lawrence Marks' statewide ADR Advisory Committee, and she's the co-chair of the New York Women's Bar Association's ADR Committee. We're also joined by Joan Levenson. She's the principal law clerk to the Honorable Deborah A. Kaplan, the administrative judge, New York County Civil Branch, and counsel to the New York State Judicial Committee on Elder Justice. Previously, Joan served as Justice Kaplan's chief of staff at the Office of Statewide Coordinating Judge for Family Violence Cases. She's worked with the New York State Judicial Institute, where she developed programs for judges and court attorneys. In addition, she has extensive mediation training, which we're happy to hear about tonight. We're joined also by Jean Norton. Jean Norton is the ADR coordinator for the Supreme Court of New York County. She's responsible for seeing the day-to-day administration of many ADR programs, including the Commercial Division ADR program, the Non-Division Commercial Mediation Program, the Matrimonial Neutral Evaluation Program, the Early Mediation and Early Settlement Conference parts as well. Jean will also oversee the upcoming rollout of the Tort Evaluation Program and the Matrimonial Mediation Pilot Program, which we'll hear about in tonight's presentation. She's responsible for organizing ADR trainings for judges, non-judicial staff, and volunteer attorneys, as well as ADR-related community outreach events and programs. Joan previously served as the director of Collaborative Family Law Center and as assistant deputy counsel in the Office of ADR. Before that, she was the senior director of Safe Horizons Domestic Violence and Immigration Law Projects. And finally, we have Danielle Weitz, who is the director of the Division of Professional and Court Services for the New York State Unified Court System. He oversees the statewide responsibilities of ADR, attorney for the child contracts, judiciary civil legal services contracts, Office of Language Access, Office of Grants and Contracts, guardianship and fiduciary services, legal information, Office of the Court Record, parent education, records management, the Children's Center Program, and the American with Disabilities Act. Previously, Dan served as the statewide ADR coordinator for 18 years, where he oversaw a statewide program of court-annexed ADR initiatives involving mediation, arbitration, neutral evaluation, parenting, coordinating, and collaborative law. He also directed the Community Dispute Resolution Centers program. He serves on the Unified Court Systems Advisory Committee on Language Access, ADR access for people with disabilities. He previously served as co-counsel to the Board of Governors of New York State Attorney-Client Fee Dispute Resolution Program. Dan is the past chair of the New York City Bar Association ADR Committee and past co-chair of the ABA Dispute Resolution Section Court ADR Committee. He's an adjunct clinical professor of mediation at Cardozo School of Law and an adjunct professor of clinical law at NYU School of Law. So welcome, panelists. Thank you so much for being here tonight. Tonight, we're going to share the history of presumptive ADR in New York, the challenges faced in rolling out this initiative, and the project and pilots that are currently underway. So perhaps the very best place to start this conversation is by discussing in broad strokes the history, the overall vision of presumptive ADR in New York. And for that, Dan, I'll turn to you to hear about the overall vision for presumptive ADR in New York.
Thank you, Danielle, and thank you, Peter, and thank you to New York Law School for hosting tonight's program. So for those of you who know me, you know that I did start out over 20 years ago with the Office of Court Administration, charged with developing ADR throughout the state. Lisa joined me soon after, and together we had been working to promote and advance the development of ADR throughout the court system. And we did that through a process called collaborative program design, where we convened stakeholder groups that would involve local judges, local court administrators, members of the bar, and different advocates to ensure that we could come up with a set of protocols that would govern the program at the local level. In many ways, we developed the infrastructure upon which we're building presumptive ADR today. When you do ADR program design, there's a number of issues that have to be discussed and agreed upon by a stakeholder group. One is the nature of referrals, how are cases going to get to ADR, the timing of referral, confidentiality, qualifications and training of mediators, and so forth. But one issue that was always most controversial was the nature of referral. Is the case going to be voluntary, opt-in? Do we leave it to the judge's discretion? And most of the programs that we developed were either voluntary opt-in, or we would give judges the discretion. That's the infrastructure that for the most part exists today until we start implementing fully presumptive ADR. I'll turn it over to Lisa in a second to tell you about that. The last point in our evolution would be that on the heels of this infrastructure, we did try to pass a few rules that went out for public comment that would have addressed what we had learned to be the biggest issue with all of our work. And that was, notwithstanding the great efforts of everyone involved to put programs together that were high quality with good mediators, great mediators, and well thought out rules, the programs were underutilized. And so we convened on a grassroots level, as well as with leadership, folks that could explore ways we could increase utilization within ADR. Judge Kaplan, who is the administrative judge for New York County Supreme Court, she was a member of that group. We focused mostly on matrimonial cases at the time. And we combined an interest that both Lisa and I have in neuroscience and nudge principles and behavioral economics to think creatively about ways to increase utilization. And so right around that same time, we had a change in administration with new leadership at the top of the court system. And we also had a change in who was the ADR coordinator. Lisa Courtney took over as the statewide ADR coordinator. And I'll turn it over to her at this point to talk about how we then progressed into the Presumptive ADR initiative that we have today.
Thank you. And Lisa, do you want the timeline? You just tell me when you want it.
Sure. Yeah, I guess in 1 minute we could put it up. I just want to make sure, since there's so many attorneys on the call today and on the webinar, and not as many mediators as we thought, that might help to define some terms that we've been throwing around. So one of them is presumptive ADR. ADR is alternative dispute resolution, but it can also be thought of as appropriate dispute resolution. The idea there being that there's an appropriate dispute resolution option for the different cases and for the different constituents that can come through the courts. And can we as a court system honor the diversity of processes that people coming through our doors may need? The idea is also that litigation need not be the default through which we experience problem solving and resolution of disputes. We are very socialized to think of it as a me versus you. Through that fight of one person against another, the truth shall come out and a decision will be rendered and justice will be served. What we know is that most courts, though, and in most contexts, people don't go litigate to the finish line, and they go through something more like a litigation, where they litigate, they negotiate, they litigate. And so part of this shift to presumptive ADR is to recognize that litigation need not be the default. And we have a chief judge who thought really big and bold and decided, let's switch the default. So not just have appropriate dispute resolution be our way of thinking about dispute resolution, but really have some primary significance to those less stressful, less costly alternatives to litigation. So with that, we can go to our timeline, because that happened in around the spring of 2018. Our Chief Judge, Janet DeFiore, and Chief Administrative Judge, Lawrence Marks, announced the formation of a statewide ADR advisory committee chaired by John Kiernan, who was the former New York City Bar Association president and a litigation partner at Debevoise & Plimpton, an international law firm. Shortly thereafter, in early 2019, the committee issued its first interim report and set of recommendations, which are in your program materials. The 3-page executive summaries in the beginning, I strongly recommend that you look at that to get a sense of this initiative. And it called for early mediation of most civil disputes, also making specific recommendations to enhance ADR infrastructure that Dan talked about, as well as partnerships. And big, bold message is really to flip the default, to switch it. So after the committee made this interim report and recommendation, our chief judge embraced it wholeheartedly. In her State of Our Judiciary in February 2019, she announced that ADR, so alternative dispute resolution or appropriate dispute resolution, is an integral part of the court's excellence initiative, an initiative designed to reduce backlog and improve efficiency and enhance the litigant experience. And so as part of the excellence initiative, most civil cases should be presumed eligible for mediation and other forms of early appropriate dispute resolution, unless certain exceptions apply. So the idea was it's not appropriate in all cases, but it's certainly more appropriate and should be more encouraged than it currently is being encouraged or utilized the way our system is currently structured. So soon after that, our chief judge and chief administrative judge tasked our talented deputy chief administrative judges for courts inside and outside New York City with leading this Herculean implementation effort. That's Judge Silver for the courts within New York City and Judge Caruso for the courts outside New York City. And they hired special ADR counsel coordinators to assist them in organizing the implementation effort, a real massive undertaking. So in the spring of 2019 through the summer, our district administrative judges throughout the court system spent their summer with their court staff tirelessly working to develop plans to realize this vision. How do we flip this switch? This initiative was not just for matrimonial or just for surrogates or just for commercial or just for small disputes. This was a system-wide initiative. So how do we do that? It's almost like the judge said, open up your closets, take everything out, and shift it, turn it upside down until you find a way to get appropriate dispute resolution as the proper lens through which to view cases. And our judges did an incredible job of developing plans and refining plans. And our senior leadership looked at those plans and said, is it presumptive? Is it early? And if not, back to the drawing board. So there really was an attempt to try to create plans that allowed for the realization of this vision. The summer of 2019, going up until March 2020, a massive training effort began. And we could talk about training, I think, in the next segment, but I just want to say that over 550 people attended the trainings that we, the ADR office and ADR council, were involved in some capacity, that Jean was involved in, that Joan was involved in on our panel, that Dan was involved in, and that you too, Danielle, were involved in, and Professor Phillips. Some of these were 90-minute trainings, some were day-long settlement skills workshops, some were 24-hour mediation training, going through 40-hour mediation trainings. Of those 550 attendees, we have 300 court staff who got full 24-hour mediation training, and then some even getting the full 40. And what was the purpose of this massive training initiative? Buy-in. This is an integral part of stakeholder development, and to create an infrastructure of court staff who, they may themselves not be the mediators on a case, but they're going to feel a lot better sending parties to mediation if they understand what it is. There was a lot of fear during this period of time. Fear on the part of court staff, are cases being taken away from us? Fear on the part of litigators, are we no longer going to be representing our clients in a familiar forum? What's happening? How can this affect our business? Fear on the part of mediators, are the courts, by training their court staff, not going to allow us to be part of the dispute resolution community and expansion? So a big part of what happened between July of 2019, really going through today, so today over Zoom, was an understanding and an appreciation of what are the fears out there, and how could we better explain that we are trying to improve effectiveness of dispute resolution. Sometimes it's efficiency, but sometimes it's a greater sense of procedural justice, which may take longer and be less efficient in the short run, but more efficient in the long term. So a big part of what happened here was the Deputy Chief Administrative Judges ADR Council, our administrative judges, the ADR office, people in charge of ADR programs, went out to different bar groups, went out to the community, went out to key stakeholders, domestic violence advocates, court staff, and explained what is alternative dispute resolution. What is mediation? How is it different from a settlement conference? In a settlement conference, the lawyers are first and foremost giving presentations to the judge. The judge or court staff may be looking at strengths and weaknesses and really focusing the team on the legal issues. The parties take a back seat. In mediation, as many of us know, the parties are front and center. They have more voice and they have greater creativity and opportunity to share what they would like to see happen with their dispute. So a lot of what's happened in the past couple of months was really an attempt to understand what the concerns are, address them, but also allow staff to walk away with key skills to be even better in their own settlement processes. So a big training effort was underway, summer and fall, and stopping through the COVID crisis, and hopefully now continuing through Zoom. In addition to that, local protocols and templates were drafted. We created an ADR SharePoint intranet site so that court staff could see. New York County, we all know, is a huge leader in ADR. You're going to hear about their amazing programs and their learning from their experiences. We want to post that for the other judicial districts to see. The 7th Judicial District also had a lot of great material. The 6th had an innovative pilot for family court. Westchester Surrogates had an innovative pilot that's being replicated in the Bronx and being tweaked. So we wanted everybody to be able to learn from each other. The 8th Judicial District had a very robust in-house ADR program. So we wanted to share these resources. We had webinars, we continue to have webinars, we continue to share resources where court staff can access them. And we've also built a data collection database. It is a separate database from the regular case management system, another Herculean undertaking requiring a lot of collaboration with different units within the Office of Court Administration, technology, court research, local administrative judges' input, chief clerk's input, so that we could actually track. An ADR is broadly defined. If you are a court attorney spending 2 hours trying to settle a case, Shouldn't we know about that? Shouldn't that be quantified and classified as ADR when you are working with the parties in that way? Similarly, if you're a community dispute resolution center mediator, or if you're a court staff mediator, or if you're a member of a court roster, we want to know about the dispute resolution efforts you are undertaking and whether or not they were successful. We also encourage people to think broadly about success. Are the litigants satisfied? Success is not just whether you settled it on the first try. Success is, did you give parties an opportunity to express themselves, to really feel heard, to feel like the neutral understood them? And now we've updated that survey to include questions about the virtual ADR experience as well. We have also been really engaging in ongoing research and outreach, as well as developing other internal infrastructural suggestions that came out of the advisory committee. So I'm going to stop now. There's just so much that's been going on, but I'm happy to fill in on some of the other points.
Thank you, Lisa. And I think, Peter, do you have a code? I know for the CLE, we need to issue codes.
That's right. Just to remind everyone who's unaccustomed to it, you all received a link for a WUFU form that requires you to put in 3 different words. And so every 25 minutes, I'll be giving you a word. Please jot it down, and then you'll be able to fill out the form that was emailed to you. The first word is chief, C-H-I-E-F, chief. Go ahead, Danielle.
Thank you, Peter. And Lisa, just to, one of the things that I heard, I think, when the announcement was made last May was, where is this coming from? It's coming from nowhere. And I think part of what I really wanted to show is the years of work that really have gone into making this happen, and that it's not some idea that someone had day one and, you know, and foisted upon everyone day 2, but that really it is a sea change. And I think that I tell my students, and I know some of them are on this webinar tonight, I say, it's so nice to have you here. I know how you've been taught to think. We're going to do things totally differently. But you have to tell that to lawyers who have been practicing, to court staff who have been doing this for years and years. And as you describe, you've taken on, I couldn't count how many Herculean efforts, but certainly it's all happening. But it did take a lot of work. And I think that brings us to the next topic, which I'd like to talk about, which is developing and working with stakeholders, and then also just some of the logistical problems, because I think that everyone who's listening on this call can hear you were touching upon many different groups, and certainly encountering resistance. And we tell in our mediations that when we have parties, we explain to them what their role is, because if it's new, there's no law and order mediation yet, hopefully that's coming, but that this is unfamiliar. And so really making people feel secure in their roles. So if we could just talk sort of about stakeholder development on the statewide level, I think that would help us understand.
Sure. So as Dan mentioned before, this foundation was laid by years of his, leadership as statewide ADR coordinator in the years before I got on board. So in some places, we already had the infrastructure, we already had the rules, we already had rosters of neutrals, but there was underutilization. So we, as part of stakeholder development, and sometimes without us there, judges took it upon themselves to find out what went wrong. Why didn't things work? And I think what we learned was, as Dan mentioned too, some behavioral economics principles that were applied in real life. People got really excited after taking a training. They got really excited by joining a roster. And then the judges just kind of forgot about it because they have their court attorney there, or nobody really said they wanted to go. They said, nah, judge, we'll stay with you. We're already here. So there was a real crisis of underutilization. So the first thing we had to do was say, where are we going to focus our efforts? It would be great if we could focus on places that already have a rich infrastructure and already have, like Supreme Court New York County is a very easy starting point, and you'll hear more about what they did. But where do you already have a rich infrastructure? How do you enhance it? How do you tweak it? How do you get another case type in there that can go through this presumptive model? Or if you don't have anything going presumptive, can you think about a case type that would benefit you? Courts that if you could make it presumptive would make your load easier. So that's also part of the challenge, that we didn't start with matrimonial or surrogates statewide. We started with each judicial district was tasked with identifying where do you have the greatest need based on volume, based on intensity of court staff effort to address it. So some of the challenges of implementation have to do with people targeting different case types at different times. So in some places it was getting mass settlement days together. In some areas it was something different. So I would say some of the challenges were not having one way of doing it.
Who is she?
Sorry.
Who is she?
Lisa's going to rejoin us in a second, but something that Lisa has alluded to was there's a statewide initiative and then it has to be boiled down. And so looking from sort of the bird's eye view is saying, what have people done? What works? What doesn't work? And then how can we make that work for us? And so now if we could, Lisa, if you want to finish, or we can also get down to the county level to see how that translates.
Yeah, and I just wanted to say addressing the concern was a really important part of stakeholder development. And so for each stakeholder group, you really had to figure out, what do they want? What are they interested in? And how can this initiative, if possible, address some of their needs? So I think with court staff, once we were able to differentiate what it was, and also for the attorneys, when they realized that we want the attorneys to participate in these processes, this is not a way to exclude them, but rather to include them in a problem-solving way, I think that went a long way.
So in other words, it's not here's a program that we're forcing upon you, but it's saying, how can we help you? And what does that look like? And obviously for each county, each court even, right? It's going to look incredibly different. And so that takes a lot of effort, because you can take those mass lessons that you described, but really boiling it down is something different. And so maybe this is a good time to bring in Joan and Jean and talk about what's been happening on the county level.
Hi, thank you. Thank you, Lisa. Good evening, everyone. Thank you for being here. If I do this a lot longer, these Zoom presentations, I really want a teleprompter. But I wanted to say first that our court, under the leadership of our administrative judge, Deborah Kaplan, is really committed to enhancing and expanding ADR options in our court. We've always been supported by Lisa's office, and Dan, as well as by our Deputy Chief Administrative Judge, George Silver, and now Lisa Denig from his office. We are really just getting stronger and stronger in terms of our ADR structure within the city and the state. We are committed to ensuring that all court users, lawyers, litigants are aware of the many alternative ways to resolve a case other than by litigation. And we've remained steadfast in that commitment during the current public health crisis, although we've had to introduce sort of new and innovative ways to implement ADR. And of course, as Lisa mentioned, when we talk about ADR options, yes, certainly the goal is presumptive mediation in most types of cases, but there are lots of other ADR options out there that we use as well. So I wanted to give you a little history about our presumptive mediation program for certain commercial cases. The title of the program is Presumptive Early Mediation Program for Non-Division Commercial Cases. I know it just sort of rolls off your tongue, but this is probably our most successful program. But I think the process utilized in creating the program illustrates some of the challenges inherent in crafting a court-sponsored presumptive mediation program and the lessons learned. This program began as a pilot in May 2017, and it called for the automatic referral of what we said was certain commercial cases to mandatory mediation. And the program has since been expanded. I mean, the types of cases that are going to that program have been expanded, and the program has lost its pilot status. Now, when we say certain commercial cases, what do we mean? We mean cases generally, for sake of simplicity, cases where the amount in controversy is under $500,000. And Lisa was talking about, how sort of assessing need in your court and what kind of cases might be amenable to mediation. These are certainly some of those cases. I think that these sort of contract and commercial cases that are not in our commercial division because the amount in controversy is under $500,000, these probably make up the most cases in our court in New York County. And I don't know if people out there know, but at any given time in New York County Supreme Civil, we've got about in total 35,000 cases pending. And these commercial cases make up a big majority of these cases. So what happens in this presumptive early mediation program? An RJI is filed, that's a request for judicial intervention is filed, and then the case is assigned to a judge. But before counsel and the parties appear before that judge, they're sent to a preliminary conference where an experienced senior settlement coordinator, Kevin Egan, conferences the case. And basically the goal of that conference is to come up with a consent order for what discovery do we need, what information needs to be exchanged in order for us to have a fruitful mediation. And then a mediator from our commercial division roster is assigned, and the mediation is scheduled. It's supposed to occur, and usually it does, within the 30-day period between the end of the exchange of information for the mediation and then the subsequent compliance conference that's scheduled before the assigned judge. So overall, the cases that are sent to this presumptive program, about 60% settle. Now these cases right now are being conferenced remotely, and the mediators are being assigned, and the mediation is taking place remotely as well, and Jean can tell you more about that. Just a word about the mediators on our court roster, on this commercial division court roster. They've been vetted. They are highly seasoned mediators and exceedingly experienced lawyers with knowledge in the commercial law area as well. But I just want to step back for a moment, because prior to the launch of this mandatory program for certain commercial cases, we had another pilot program, and it was called the 1 in 5 Pilot Project. And it ran for about a year and a half between 2014 and 2016. And the lessons we learned from the 1 in 5 pilot really contributed to the design of what is now our presumptive program that I just told you about. In the 1 in 5 project, as the name suggests, every 5th case that was filed was sent to mediation, was just automatically sent to mandatory mediation. And this ended up not working well because many of the referrals were just not appropriate for mediation. The case was, the case was filed only because there was going to be a default. The case was filed because it was in a foreign jurisdiction, but a deposition of somebody in New York had to be taken, so you had to file a case. There was a dispositive motion pending that was going to, resolve the case potentially. So we weren't generating enough cases to get into the program. The other problem was, or one of the other problems was, that the 1 in 5 pilot project allowed counsel 120 days from the filing of a request for judicial intervention, either to engage the services of a mediator or ask our ADR coordinator to assign a mediator. In a significant number of cases, guess what? They didn't do anything. So what did we learn? First, this sort of strict arbitrary selection of cases doesn't always work. So why not say presumptively all the cases go to mediation? Of course, that doesn't mean that cases won't be exempted, but the default will be that they do go to mediation, and those cases that are not appropriate won't. What else? 120 days, too long a period of time to allow the parties to engage a mediator or to ask the ADR coordinator to assign someone. What might work better? What is working better is a shorter period of time for the mediation to take place. And why not just have the ADR coordinator assign the mediator and then put the onus on counsel if they don't want to use the services of that assigned mediator? None of these changes would have worked or may not have worked. Lawyers might not have been supportive of the program unless they'd witnessed the lack of success of the 1 in 5 pilot program. I mean, it's called a pilot for a reason. It's supposed to be experimental. It doesn't always work. And, a failed pilot is not a bad thing because it begat a very successful program. Also, what did we learn? And although we had stakeholders involved in the 1 in 5 pilot project as well, but we learned, and we emphasized that the success, as Lisa talked about, of any program depends on stakeholders being involved. Lawyers, court staff, judges, mediators, they all have to be involved in the planning process. Now, I wasn't a part of the planning process for the Presumptive ADR program in the commercial cases, but I was actively involved in the creation of our Presumptive Matrimonial Mediation program that was just about to launch in April, and we sort of had to pivot and change the plan, at least temporarily. But in order to get this program off the ground, we worked with a subcommittee of our Matrimonial Advisory Committee in our court. Judge Kaplan co-chairs that committee, and with a private attorney. And the committee is a very diverse committee. It's made up of a wide range of attorneys, attorney mediators, and as well as legal service attorneys. And all of our matrimonial judges are also part of the committee. But as Lisa mentioned, Dan, I'm sorry, even before Judge Kaplan was the administrative judge in New York County, while she was the statewide coordinating judge for family violence cases and I was her chief of staff, we were part of a statewide working group led by Lisa and Dan, focused on how the courts might introduce mediation in contested matrimonial cases. So we've been thinking about this for a long time, and I think particularly with respect to contested matrimonial cases, where the issues are highly personal, there can be a great deal of conflict, and where some lawyers are, let's say, zealous in the representation of their clients, and that's not a bad thing, but you really have to think about how to structure a presumptive mediation program that lawyers and the parties might be open to trying. One very important consideration is to have a diverse group of mediators and experienced mediators. So we created an application, the goal of which was to attract a strong roster of attorney mediators with matrimonial law expertise. We disseminated that application widely. We got about 100 applications, and most of the applicants were exceptional. They come from a wide variety of backgrounds, and the languages spoken in no particular order are Spanish, French, Hebrew, Chinese, Korean, Yiddish, Russian, Ukrainian, Arabic. We also attracted experienced matrimonial attorneys, litigators, who have mediation training, but not extensive experience in mediation. And the hope is that they'll be able to co-mediate with seasoned mediators to gain mediation experience. In our view, the more trained, experienced, diverse mediators, the better.
Thank you, Joan. And certainly the co-mediation that you were talking about, where you have someone with subject matter knowledge paired with a seasoned mediator, other courts have used as well. The Surrogates Court in Westchester has been very successful in their program. Something else, Joan, that you mentioned were the zealous advocates and the zealous attorneys. And Jean, I have a feeling that you deal with a lot of zealous advocates and attorneys, and maybe we can talk about that for a moment, just in terms of what it's like, some of the challenges on the local level.
I mean, I think some of the challenges when you do program design is that you're designing a program for all kinds of court users. So not everybody speaks English. Not everybody has access to pay for a mediator fee. Not everyone has an attorney. I mean, you have many cases where one party is represented and the other party is pro se. How do you send that type of case to mediation and, keep in mind the party's procedural justice so they understand what's happening, and making sure if they do need an interpreter that they have one every step of the way for the prep work, for all the pre-mediation talking points. But beyond that, with the zealous counsel, I think that a lot of them, once they go to mediation a couple of times, some of them, not all of them, end up picking up some of the language, and some of them become much more supportive when they start doing the process. Having managed the Collaborative Family Law Center for so many years, you'd see attorneys in the very beginning would come with their clients, and they were this was all divorce mediation. They were so opposed to it. There's no way this would work, and I'm going to come and sit there and just, be a menace. And after they saw that it did work, eventually they would stop coming with clients, and maybe they would come for the first session, but maybe not the subsequent sessions, or they were a lot more supportive. I mean, there's definitely some of them that are not changing their mind. But I think that even within that group, a lot of them say, if that's what my client wants, I'll do it. That's not what I do. That's not what people pay me for, but that's not what people are coming to me. But they're not necessarily as opposed to it. I think a lot of the change within the bar has been from a lot of outreach and a lot of efforts to bring them into the fold and to see what mediation looks like. When I first started doing mediation work, a number of attorneys still thought it was arbitration, that they were going to go somewhere and their client was going to be told something, or neutral evaluation. That type of process. And once they saw what was going on with mediation, they felt a little bit different about it. But again, it is a complete transformational shift in your mind from what you're taught in law school to becoming a mediator and then trying to incorporate that. A lot of attorneys will say, that's not my job to do that. My job is to do what my client wants me to do, or I can't possibly mediate until I have every piece of discovery available on earth, and then I can give them an assessment of this case. People may change their mind with time. When I was mediating with attorneys, at some points we would say things to them like, is what you're doing helpful? Do you think what you're doing is helpful? Because what they were doing was causing problems. I mean, the parties would be so close to settling, and they were all on the same page, and then you'd have an attorney that was would kind of thwart it with like, well, what about this? And it's like, well, that might happen, but it seems unlikely. But you could also plan for that. We can put in clauses. You know, you can definitely think about that. It doesn't mean you have to blow up a settlement because something might happen, like someone might move to a different state, because that could happen anytime anyway. So I think we've made progress there, but people are who they are. You know, people are drawn to certain fields because that's what they kind of like to do that. But I think it's definitely in the 10 years I've been doing this work, an entire sea change in the way that people perceive ADR and mediation, and how amenable they are to going at this point.
The other thing I think that really changes perspective is when the lawyers take the 40-hour mediation training.
Yes.
They come back and say, I thought I knew what mediation was. I had no idea. And it really just dramatically changes how they view a case and how they view mediation generally.
We had several of the matrimonial mediators on our roster, are very well-known matrimonial attorneys that initially started the stakeholder process saying, this is the worst idea ever. I will never send a client to mediate. And they were just completely opposed to it. And then they took the 40-hour training and they became mediators too. I mean, they're still litigators. That's their prime job. But it was, the way that some of them describe it is a way that they transformed the entire way that they looked at their whole life of conflict. So I think that's really inspiring. I know that many years ago, we also OCA paid for a lot of legal services attorneys to go to mediation training because they were so opposed to mediation. And some of them also became mediators. Some of them walked out saying, well, this is not for me, but I don't hate it and I won't stand in your way. And now I understand it, which is still, I mean, that's a positive change of it's not what I want to do, but I won't thwart it.
And I think something, at least that I see and that I'm hearing here as well, is it's getting people into the room. I mean, if you're opposed to something and you probably don't have a clear idea of what it is yet, right? It's getting them into the room, letting them see what's possible. Getting them into the training is exposing them in a different way. But like you say, it's really changing perhaps the way they see how they're supposed to help the client. And so that's why we need to take advantage and hopefully get them in the room and get them in the training. And on that note, I think we should also now talk a little bit about training. I think since many of the audience members are attorneys and perhaps not mediators, that's something that we should probably take a dive into just so people understand. We've heard from Joan about the qualifications, the diverse backgrounds of the mediators who get onto the rosters. We've heard from Jean about the matrimonial. So I'm going to let Peter say his code, and then Lisa, I was hoping we could talk about training.
Sure. Thank you. The second code word for this evening is judge. 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 Thank you.
All right. So Lisa, maybe we could talk a little bit about training. I know that we talked about part 146. We've heard 24-hour, 40-hour. So maybe we can talk a little bit about what's required and then sort of what's been happening.
Sure. So part 146 of the rules of the Chief Administrative Judge call for 24 hours of initial mediation training and then 16 hours of additional mediation training. And this 40-hour kind of gold standard is what is basically required in various permutations throughout the United States and on federal court rosters as well. It's a range between 24 and 40. And there was a lot of work done around how much better the mediators are when they've had training and when they've had experience. So part 146 calls for both. You need 40 hours of training, and then you need recent experience mediating actual cases. But there's a lot of flexibility in how you can get the recent experience mediating actual cases. You could join a formal apprenticeship. If you have a mediation training provider that also offers an apprenticeship, like many of our community dispute resolution centers do, then you get that training and the oversight, the opportunity to practice, to evaluate and be evaluated, to observe and be observed. So that's one route, a formal apprenticeship. Another route could be an informal mentorship. You find a friend who's a mediator and say, hey, can you get consent of the parties and allow me to sit in on a mediation so I can observe? And then there's mediation or co-mediation. Some of our rosters say, like the new Supreme Court in Bronx County roster says, you need to have 3 mediations under your belt in the Supreme Court. So there is really a mix. it's purposely designed that way so that you could either do a formal apprenticeship, you could mediate, you could co-mediate, and it's up to the local administrative judge to decide which constellation of mix and match observations, co-mediations are required. So the reason is because when you are mediating for a court program, you are a representative of the court. The court is sending you there. If the court is choosing a mediator, we have a lot of responsibility to make sure we're making a fair choice, a good choice, and somebody who knows what they're doing. So that's why there's these training requirements, and that's why there's also this experience requirement. But again, it's up to the local administrative judge. If they say, for example, in the commercial division, you need to have X number of years of commercial law experience, in addition to taking a 40-hour training. It's great that you were a tax lawyer, but if you don't have some commercial law experience in this context, it may not, maybe tax is not a great idea, but a great example. But if you were, doing landlord-tenant law and now you want to do commercial division, you might need some supplementation in terms of your subject matter expertise. And finally, final placement is in the discretion of the administrative judge. And partly that's because we want to make sure that the judge feels comfortable with the body of neutrals that are operating under her auspices. In addition, there's 6 hours of continuing education. That's continuing mediator education. But if you're on the matrimonial roster, it could be changes in, the tax law that impact families, or changes in spousal support. So we're very flexible about how we interpret that, and that's up to local ADR coordinators to decide how to enforce that. They may deliver their own, say, a domestic violence training or an implicit bias training or something else that they think would be helpful for their roster to develop some expertise in. And they can either offer it in-house or people can get it from other sources.
So it sounds as if there's the initial training is everybody goes through the same kind of boot camp. And then depending on what is required locally, it might be, you need up to 40 hours, but certainly the recent experience seems to be the thing that's really particular and you'd need to check. But it seems as if you can do that through many ways, either through apprenticeships, as you described. So maybe now it is a good time also to hear from Joan and Jean just about their experiences with the training in terms of maybe even specialized programs or in general.
Sorry about that. It's late in the day. It's hard to keep them corralled in the same place. I banished them upstairs, but that didn't work. Well, we have a lot of exciting training ideas coming up, but with the courts being semi-shut down for COVID and some of us at home, the court is using Skype for Business, which is very difficult to do an actual training. Zoom, you can do it, but with the technology we have, some of those will probably have to wait until a little bit later in the year. Or what we've been doing so far is finding a bar association to sponsor it so that they can use Zoom, and then we can do the training that way. But we had wanted to do a whole series of trainings of both mediator orientations, like welcoming new mediators onto our panel and kind of explaining the process for whatever program that they were going to be working with, the paperwork and who everybody was and how everything was going to happen, but also some trainings for best practices for mediators. I have found that some mediators are very successful in private practice and out-of-court cases, but for a variety of different reasons, that success doesn't always translate into court and next mediation. It's a little bit different, but there are some ways to make it a little more successful. There's people who have very high settlement rates and they do structure it in a certain way. So setting up a training where we're kind of teaching people, this is what other people have been doing that has been working really well. We've also, many of our staff, our court attorney staff, our referees, law clerks, a lot of the JHOs have been to mediation trainings over the years. And so in some ways trying to supplement that, because, if you go to a training once 5 years ago, it might have been impactful at the time, but if you're not practicing, if you're not remembering those skills, it's helpful, but it's not the same as having something ongoing. So my thinking on that was to try to break it down into very discrete skills. We would be taught in mediation, positions of interest, reframing. And, it's hard for court staff to take 40 hours off at time to go to a mediation training, but it is a little easier to be able to do little tiny pieces in 2-hour chunks, which are basically settlement skills. We've also, last year we had a CLE program called ADR Options in New York County, It was mostly attended by attorneys, which was fantastic, because sometimes a lot of our outreach ends up with mediators who are already in our fold and they're already working with us. But if we don't have the attorneys asking for the programs and supporting the programs, we're missing a core user. So to have that many attorneys come to hear about what the options are and find out how they work, that was super successful. I think that within the attorney community, the more of them understand what's going to happen, the less that they complain about it or they fight it. If they don't understand it, I think that their instinct is to say, no, I'm not going to do this because they don't want to, be embarrassed, or it's just not worth the effort to figure it out. But once they do know and they understand, I think that it makes it so much better. We do have ongoing efforts with domestic violence training for our mediators, particularly on our matrimonial panels, some different like skill-based trainings. We did, I guess it was last month. Time is still flying by. I'm like, what month is it now? How is it June already? Sorry, I'll be right back.
Well, the other thing that we did that Jean didn't mention is that we had a tort neutral evaluation training program last fall that Lisa helped with, and was Dan there too? I'm blanking. Oh my God, I'm so sorry. Lisa and Dan, and we also had an attorney who was a mediator participate, because we like to always include an attorney in the program. We had about 50 attorneys that sort of practice personal injury, tort law, attend the training, and the idea is to have a tort neutral evaluation program in place soon. Again, everything sort of, was stalled slightly given the current pandemic, but that we had a great turnout. And again, these were lawyers that were mostly litigators who really, this is not mediation, it's neutral evaluation, but still this is an alternative dispute resolution, another way of resolving a case other than going to trial. And they really were very excited about doing that. And we're very excited about getting that program up and running also.
And it sounds as if the thing that seems to be working is by one, informing, and two, showing there's not one path, right? These are skills that can translate if you're a court staff neutral, if you're an attorney using it. But that something I hear too is that you do need to have that time to have the practice, and it's hard if it's not part of your everyday. So having those little pieces and having workshops is something that's been useful. I've heard also that peer groups are useful for that too, just people sharing their experiences, which brings us also to talking about this, and we've mentioned them oftentimes, which is rosters. So talking about trainings and talking about how to get on a roster. And so, there's been a lot of interest about how would I get on a roster? And certainly when we took the poll, we saw that there were plenty of people who were interested who had questions. So maybe Lisa, you could take the lead on this.
Sure. And I just want to say that so many people take a mediation training, and even if they decide this isn't really for them, or once they realize it's really hard to make a living as a mediator, though it is a lot easier to kind of add it as a tool in your toolkit. So I just want to have transparency around that. It is hard, even if you're on a court roster, even if you get the training, even if you co-mediate, observe, get the experience, get selected. There's only so many times you're going to get selected. So you really don't want to rely on it or rely only on the courts as a way to get your business. But what it does do is you take the training, it's 40 hours, you observe or co-mediate, you apply to join a court roster. And just as we mentioned before, for outside New York City, if you're in the West, I can give you the names of the ADR coordinators, and then they could plug you into the even further local coordinators. I could put that in the chat if you like. But for Westchester, Long Island, and the Capital District, it's Joel Coulis. It's Bridget O'Connell for the 5th, 6th, 7th, and 8th Judicial Districts in Western New York. In New York City, other than Jean Norton for Supreme Court New York County, it's Lisa Denig. She could plug you into the other rosters in New York City. So I could post that on the chat so you know who to contact. But the first step really is getting the mediation training, and then being willing to get that experience, and then using whatever subject matter expertise you already have to kind of build your practice, if that's what you want to do. So the roster is there to allow us as the court staff to refer people to who have taken a quality training, such as the one you plan on offering in July, which we are so thrilled to hear that you guys are offering it. You got really great feedback from the attendees of the training you did for our court staff. So thank you. it's hard to get good quality trainers. So we're really excited when there's an excellent training coming, and people find it really helpful, even as litigators, to get that training and then to be even more effective as litigators. So the directories and the rosters are also not going to be set up in every single county for each case type. There is different demands in different parts of the state. There's different needs. In some parts of the state, there aren't enough lawyers. In some parts of the state, the lawyers would be conflicted out if they became neutrals. So what we did in certain parts of the state, we capitalized on the federal court rosters. Downstate, there's less of an issue. But we recently surveyed over 800 mediators who we know to be associated with the Northern District of New York, the Western District of New York, and the existing state court rosters, to ask them to please re-engage with us, the central administration. Let us know, do you mediate? Do you mediate virtually? Have you taken training? Do you have experience? Do you speak languages fluently other than English? Can you contribute to diversity on a panel and to our court users and better reflect the communities we serve? And we surveyed them, and we had over a 60% response rate, which was pretty great. And then we individually checked with some folks who didn't respond, just to check, do you still want to remain on the roster? So we really are trying to organize in one central location everybody who the court in local judicial districts has already approved to mediate, and who the federal courts in regions where we don't have that same richness of dispute resolution experience, to onboard them kind of provisionally to our rosters. So rosters are in the discretion, again, of the local administrative judge if he or she wants to create one. In some of our counties, it's enough to have court staff trained as neutrals. They don't have the caseload to warrant sending out to a roster. So what we do there is persuade them, well, even if you don't need it from an efficiency, reduce the numbers perspective, do you have interpersonal disputes and families creating kind of backlogs with their intra-fighting, and maybe think of referring those cases to mediators. So we still don't think it's just a numbers game. It's also offering something substantively different for people by offering them mediation.
So it sounds like, again, it's not one size fits all, but it's seeing the need. And for the rosters, I know only because I got a series of emails, which is exciting because I know there are many mediators, hopefully, who are watching here who have been waiting for this moment. And certainly it's been a lot to collect just locally, but then to have one repository would be incredible. But I'm glad that I'm not in charge of making it. But speaking of rosters and the qualifications and looking at the candidates, I know something that has become a very big issue is how do you ensure, and we heard a little from Jean and Joan about this as well in terms of who is on the roster, but ensuring that there's a diverse population on the roster. So we know a lot of times when cases get referred in that the parties, come into the room, and we want to make sure that that everybody is comfortable and that everybody is represented. So can we talk a little bit about how you approach the issue of diversity? And I think you and Dan had spoken about this before.
Dan, do you want to start?
Yep, just trying to get the camera to work again. The issue of diversity has been one that the ADR community has been struggling with for years. I mean, obviously, society has been struggling with it for years. So there's a number of things that, and Lisa can talk a lot about it as well, that we in the court system have tried to do. Obviously, whenever we've done trainings, we've tried to advertise them to as many diverse bar associations as possible, to recruit people for rosters that would satisfy our need for greater diversity. And I think to the extent to which we've fallen short, it's just an example of the way in which society has fallen short in its ability to address some of these issues. There have been many programs, some of them at New York Law School and elsewhere, to talk about the challenges, and different ADR providers have found ways of doing it. Whether it's, what Joan talked before about one of the program design issues is who selects the neutral. Should the courts assign the neutral, or should the parties choose the neutral? Now think about that just from the generic mediation context where you would think, well, let the parties pick. If they can agree on a mediator, for example, then they're more likely to buy into that mediator. But at the same time, what if that's undermining our efforts to increase the opportunities for diverse neutrals to get more experience and so forth? So we're doing a lot of thinking in that area of really little nudge principles too that we could do to influence the attention paid to diversity in the ADR field and to make more opportunities available for neutrals who want to get involved.
So I have three things to add. Thank you, Dan. I have 3 points to add about that. One is that part of the ADR initiative includes court staff. We have been much more successful recruiting people to join the court family who are, represent more diverse populations. We have great diversity in the court attorneys, in the housing court, in the family court, and in the Supreme Court, and other courts as well. And so that already makes us feel comfortable when people in the dispute resolution field say, hey, why aren't you expanding your rosters? Why aren't you growing it? And Jean might say, but I already have 175 people and they're not all getting the cases that they want to get, even though we're picking people. So it's not just about becoming a mediator. It's also about, are we offering dispute resolution options, including access to a trusted court staff neutral who looks and represents and lives in the community in which people are coming to the court for a solution. So I think we have done a better job with recruiting court staff from more diverse backgrounds, and we have commissions dedicated to that, and we have offices and units dedicated to that. And our chief judge recently announced a redoubling of the effort to confront issues of diversity and racism and institutional practices to really look inward. So I think it's something we're always kind of wrestling with and investigating for ourselves. And so I think, yes, we've been more successful in terms of the court family. In terms of rosters, part of the challenge is it costs a lot of money to have to take all these trainings and then to volunteer for free and then to not get picked if judges aren't going to use you, or if judges are going to say, I'm going to set up a roster, but I'm not making it presumptive, or I'm making it voluntary. So you have much fewer opportunities than if the system is set up that only the same people get to be picked because the parties are picking the same people. So we added some things to applications. We added a diversity statement that we really took from the Southern District of New York and from the ADR Inclusion Network. And in true style as leaders, Judge Kaplan and Joan embraced the diversity statement and put it on the commercial division application program, asking you before you can even click on an application how you contribute to the diversity that we're seeking to expand upon in our community. So it says the New York County Supreme Court serves a wide variety of litigants, persons of varying age, race, ethnicity, national origin, gender, sexual orientation, physical or mental ability, religion, socioeconomic, and family status. The court's program recognizes that neutrals with a wide variety of cultural and life experiences enrich the ADR process. It's important that the program attract and retain neutrals who represent a range of personal and professional backgrounds. So there's an entire statement dedicated to this before you click on the application. We've also added in other applications and encouraged other judicial districts to add an optional diversity statement. Please share how you would contribute to a mediation panel that is diverse and reflective of the demographics of the court users in the community in which you seek to serve. And we also ask about language. Are you fluent in any languages other than English? Please share and indicate if you have ever mediated in that language. So it's not enough to speak another language, but have you mediated in that language? So we are also trying to fill other access to justice gaps every time we put out an application. So again, as Dan said, these are problems in society that we're not wholly and solely responsible for, but we are very dedicated as a community to trying to increase the attention and efforts in this area.
And I think, Joan, you spoke before too about, at least on the commercial division, or looking at the different languages and ensuring that you see representation from different groups to make sure that you can provide services for a wide variety of parties.
That's actually our new matrimonial mediation roster. And those were exactly the questions that Lisa referenced that were on our application that Jean helped to create. What sort of diversity do you bring to this? What languages do you speak? Do you mediate in these languages? And that's what I think helped us to generate what seems like probably one of the most diverse rosters we've had.
You know,
I also-
Danielle,
Oh, sorry, Dan, go ahead.
I was only going to add, you know, one of the other things that we've done is in the training of mediators, put a lot of emphasis on cultural competency so that mediators are able to recognize and deal with issues of bias and so forth in their own practice. Sorry, Jean, go ahead.
One of the other exciting developments around diversity in our rosters, I think, is now that people are becoming acclimated to Zoom mediation, which, you know, it took a little time for mediators to learn that platform or whatever platform they're using. It doesn't really matter where your office is. You could be anywhere. You could be upstate. You could be downstate. So whereas in the past, like, people may not have wanted to pick a mediator that had an office 3 counties away, because in New York City, that could be 2 hours of driving. That mediator might not have been interested in a New York County case or a Bronx case or a Brooklyn case. Now we have the option to expand the rosters of people from all over that have language skills and, you know, different diverse backgrounds. So makes it a lot more accessible.
I think making it accessible, as you say, and also making sure that the mediators understand the importance of it by including it in the training. I know that that's a big push, especially in continuing mediator training, is having courses on something like implicit bias or understanding cultural differences. I know New York Peace ran one with Genesis Fisher, who's also my co-professor, so I have to plug her because she does a wonderful program. But it's really important to help mediators understand. And so requiring that and making it part of the practice certainly moves it forward. And Jean, maybe because Joan had mentioned the matrimonial pilot and the diversity of that panel, we are running a little low on time, and I'd love to leave time for questions, but would you mind sharing just a little bit about the matrimonial pilot that you're running?
Sure. So that was initially supposed to be a presumptive pilot that would be operating out of 2 courtrooms, and it was designed as in every other case. In one courtroom would be even index numbers, and the other courtroom would be odd index numbers, with a goal of 50 cases to be sent for the entire year. I know that sometimes the idea is to think big and send as many cases as you can at the same time, but there is a benefit to starting small and to see how it goes, and then to fixing problems and, you know, creating the rest of the program around that. That program was supposed to start in April, and obviously preliminary conferences were all postponed at that time. So we ended up changing that model to make it, you know, we're taking cases at any stage of litigation for matrimonials, and all the judges are welcome to use it. It's a little bit different. We initially had the Peace Institute was going to be on site to screen for DV, and now it's being screened remotely, which is still, we're able to do it that way. But it's operating a little bit differently, but it has been somewhat successful. I mean, people aren't opposed to it. I think that some people have come to me, they get the referral from the judge and they don't really actually know what they're doing. They've never had mediation before, or they're not really sure. The attorneys have no idea what they're getting into. So I do an ADR conference with them, and I go over different options, because internally we have a neutral evaluation program, we have a matrimonial mediation program, we have a parent coordinator, and try to find out what their needs are and what would best suit that particular case type. So I've done that with a number of cases, and that's been somewhat successful, because they get to ask questions to someone who's not a judge, and it's not on the record, and it's not, you know, their client isn't necessarily watching them. Most of the time the client doesn't come to that prep meeting. So I think that actually has been helpful generally, and if we were all in the courthouse, somebody would be in the courthouse doing that work and explaining the program to them, but it's too hard to have me go to all the conferences with judges to explain that little piece of the puzzle. So I've been doing it that way. It's been interesting to find out, like, I think people are super candid in that environment, because it's different, what they're worried about.
Gives you the opportunity beforehand to help guide them. Maybe you could record a clip and they'd show a clip of you before everything. And that brings to light the last thing, which is now it's virtual. You know, it was meant to be screened, it was meant to be in the courthouse, but now we've entered this brave new world where we're all on Zoom. And so something I think to note, and maybe I say both of you because I see Lisa and Jean on camera, is mediations continue. I mean, this program is continuing through the pandemic, adjusting either through Skype for Business, which I don't think anyone has plugged here, but you know, through that and other forms. And so the work is going on. So maybe if anyone wants to speak to that, and then we can get to some questions.
I think with the virtual mediations, it's been definitely, I know there's tons of work being done, and a lot of mediators are super busy with that. I think there has been like a learning curve for mediators to get up to speed. And if you just watched a webinar on Zoom for mediation and you haven't practiced, you're unlikely to be super successful the first time, because it's not, it does take a little bit of work to get to the same skill set you would be in person. But I think some mediators have done it. And a lot of the attorneys have preferred it that way, because they don't have to go anywhere. They can still stay in their office and do work or do other things. Some of the mediators have liked it. Some of the attorneys have been a little bit opposed to it, but I think that underneath that, it's because it's their first mediation, and the idea of doing it on a Zoom platform is probably a little bit frightening for them. And I can completely understand. People are staring at you. You can't, it's harder to read the room and look around and see what the process is. It's a very different dynamic. But I think that all of that's easily resolvable. People can, practice. Within the matrimonial context, the safety considerations are different when you're doing a Zoom type mediation. I mean, unfortunately, my children Zoom bombed my presentation multiple times. If you have a family that is in the midst of a divorce, if they're both living together and they're doing a Zoom mediation from 2 different rooms and kids come in and out, the last thing you want to have is a child overhear that mediation, or somehow, I'd like to think that nobody would involve their child with it, but having done divorces enough, I know that someone probably would bring their child in and it's like, go ahead and tell everyone how much, that was terrible or something like that. So you want to plan around that when people are living together. If they're living apart and you have a child enter the picture and the other parent hasn't seen the child in a while, that can be jarring for the child who's, oh, dad's on the screen, I want to show him my Minecraft village. If the mediator hasn't prepared for that and doesn't have a immediate way of dealing with it, that pause or that not really being certain what to do can derail your entire mediation. You can plan for it, and it will happen. So you just have to plan for those types of emergencies. Or people who are stuck together in a pandemic that hate each other, and they're going to do their mediation together, and one from the bathroom and one from the bedroom. And a normal matrimonial mediation, if people were very high conflict, you would make arrangements for them to leave separately. What's the plan? One of you will go and have, coffee with your cousin, or, visit a friend, or do something so you're not leaving together and going home together. In this environment, I mean, it's starting to open up a little bit better, but there's a time period where you couldn't really go and do anything. So what do you have to plan for that type of conflict within the house so you don't make it worse, do no harm type of philosophy. But people have done it very successfully. And I know within the family context, a lot of the participants have preferred it that way, because they don't have to go anywhere. They don't have to take off their work. They don't have to get a babysitter. They don't have to do all kinds of things.
And Danielle, I guess everyone should be aware that judges and their court staff have been conducting settlement conferences for the last 80 days or more remotely, and with great success.
Peter, in the picture, but it's good to know that this work continues and it is adapting. It does take a lot. It is a steep learning curve, but that the initiative is moving on.
There are some really well-framed questions, practically none of which we can get to, but let me just ask it at the outset. Lisa, in the event that you have been trained in another court's, if you've satisfied another court's requirement, do you have to go through all of Part 146 again, or can you be grandfathered in, or what?
So that's a great question. It really is case by case, and it depends on what your background is and what the roster is. So for example, if you have a surrogates court background and you want to apply to a surrogates court roster, and you took training a while ago and you observed something recently, it should be fine. If you have that subject matter expertise that a certain court is looking for, you have the mediation training you've observed, or you've mediated but in a different context, but you have the subject matter expertise of the same field in which you're going. I think the concerns are where you're a matrimonial lawyer and now you want to join the commercial division. That's where it doesn't always make sense. So it really depends on what the roster is that you'd like to join. Or let's say you went to law school 20 years ago, you took a mediation clinic there, but you haven't really been engaged, but then you took a refresher, some kind of course. I think an ADR coordinator would look at that positively if you tried to stay engaged in the ADR world, even if you didn't retake a 40-hour training. I don't think anyone thinks people need to retake a 40-hour training.
And a lot of questions, I think, I hope, are probably going to be resolved if we could direct people to the right place. who in my judicial district can I, where are the trainings, who is the contact person, things like that. Now, we did send the two court resource links. Are they the best way for people to learn more about how to take the next step in this process and how to learn more about what's happening in their district?
So we're in the process of revamping some of the websites to include the names of the local ADR coordinators, but right now, in some of the parts, their names are not yet up there. Some of the local ADR coordinators were hired right before the pandemic, and our courts moved right to virtual courts. So we haven't been focused as much on the websites as much as we've been focused on, virtual courts and operations. So I could give you the names of the regional coordinators, one for New York City, one for outside New York City, and then the two for outside New York City, one in Western New York, one in Northern New York. I could type that into the chat if that's helpful.
Why don't you email it to me? I'm going to send to everybody who was here,
Perfect.
And then I'll send that out to everybody who was a participant this afternoon.
Great. That will be more comprehensive too. I could give more granular detail about who to contact for different courts. That
would be great. And I hope that satisfies everyone else. I'm very sorry that we couldn't get to all these cool, mediator as I am, I particularly like several questions about how do I get paid? But these things will eventually become apparent in the fullness of time. In order to satisfy the CLE requirements before we leave, I do want to give you the third of the three codes, and that is DiFiore, D-I-F-I-O-R-E. The third code word is DiFiore, D-I-F-I-O-R-E. Everyone will be receiving information tomorrow that I hope will include information on the training that Danielle and I are going to be giving in July, which is the first 26-hour training for the initial satisfaction of Part 146. Anything else, Danielle?
I think that just so people know, I know the payment thing is a big, and there are courts that are paying, and so I know know that we'll review the Q&A and as much as we can to gather information so that know that your questions aren't going into a void. And I think Lisa would like to add something on that.
Yeah, I just want to say quickly that right now we don't have a statute the way other states have statutes that authorize people to go to mediation and order them to pay for it. We're lucky that we have an administrative order very recently promulgated on May 1st. It's Administrative Order 87/20 that Judge Marks authorizes judges to refer parties to mediators, including mediators on court rosters, or to court staff for ADR, or to CDRCs. So that's a very good positive first step, a statewide administrative order from our chief administrative judge. So fingers crossed. But until we have a statute that authorizes us to order people to mediation and to pay for it, what we could do is order them to an initial session. And that initial session could be 45 minutes, 90 minutes, 2 hours, 3 hours. Thereafter, the parties see the value after you, the mediator, have persuaded them about what this process is and the value it provides, and thereafter they can pay you. Or you've done your service, Jean calls you to mediate a case, but you just mediated your free 4 hours yesterday, so people want to pick her again, they could say, well, you could pick me, but you have to pay for it this time. And then that's how people can get around that as well, so they're not just giving free time.
All right, I just want to say thank you to all of the panelists. I think this was so informative. As always, I've learned 30 new things tonight. I hope that the audience enjoyed it as well. And thank you to New York Law School and to the ADR Skills Program. And Peter, I'll let you walk us out here.
Well, the same thing. On behalf of the school, we're very greatly in debt to you, and we're very appreciative of your willingness to help out the legal community in the way that you're doing. Everyone on the Zoom will be hearing from us tomorrow. If you have any questions, we're at adr.nyls.edu. We thank you for your support and for your participation. Thank you all.